Is your inheritance divisible in a divorce? My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. It's a very good question whether or not inheritance is divisible in a divorce, because after all, it does often come up during a marriage. Somebody dies and boom, all of a sudden there's a big windfall. So the question is, can the person who is the party to the divorce keep separately their own inheritance so they don't have to share it with anybody? Well, generally speaking, inheritance, yes. Inheritance is going to be considered separate property, provided that you don't go do something to convert it from separate property to marital property. Now, what's the thing that you can do? Well, you can commingle it. If you get a $100,000 inheritance and you take the money and you put it in a joint account with your husband or wife, if you do that, you have essentially gifted your separate inheritance to the marriage. And now if there's a divorce and there's $100,000 in from your inheritance, 50 goes to you, 50 goes to the other person. You've gifted it to the marriage, and you've got to watch out for that. If you want to keep it separate, keep good records. Make sure that it's obvious that this account was set up. This is the money that funded it. This is the inheritance money. It goes in there. It's never been mixed up with any other money. And then you get much closer to the court saying, you know what, we're going to keep that separate. You got to watch out, though, if you begin to do things which suggest that in your mind, this money is for the marriage. So if you keep it separate, but begin to use it to pay marital bills, marital liabilities, at that point, somebody can say, well, wait a minute, here we all think this is marital, and now all of a sudden we're getting divorced, it's become separate? Well, how does that work? So that could become a little bit murky as the court tries to distinguish what was the intention of the parties. Did the parties mean to keep it separate or not? Now, different states have different rules regarding this, but you should, if you're in this situation, talk to your attorney about it and get some guidance on how you might go about making sure to keep it separate so that if there's a problem later on, it can still be regarded as your inheritance from your family and not subject to division. If you have any questions about that, reach out and we'll be glad to help you out.
248-588-3330